Okay, so today we are dealing with mood preparation. Okay, every time you are preparing for the mood, what is required of you basically, first understand what you're going to do. This being a criminal week, we all know that the general rule in regards to criminal law, every person is presumed innocent until he or she pleads guilty. In criminal law, whenever you are at LDC, first ask yourself, under what circumstances can I be cancelled in private practice? Under what circumstances can I be the RSA? And under what circumstances can I be a judicial officer? Okay, so you should be able to tell that if a question comes in this line, I know the role play. Okay, because the role play is that practical part of the workshop, and that is the moot or is. Okay, so in criminal, counsel in private practice has different roles on different stages. Upon commencement, or upon taking plea, that's what we call commencement of the trial. Okay, commencement of the trial. The ultimate duty of counsel in private practice or on state brief is basically to make an application for bail, provided that your client has taken a plea of not guilt. Then you can proceed and make an application for bail. Okay. Then, if not that, another duty of counsel is to make submissions on no case to answer. That will be your next workshop that is ending this term when you're making submissions on no case to answer. Okay. But as of now, at this moment, we have the ultimate duty to make an application for bail. So you first ask yourself, do you understand what you're going to apply for? You understand what is bail, or you just know it is a constitutional right? Okay, so before you say you are cancelled for the week, understand your case and the subject matter. So, applicants, do you understand what you're going to apply for? That even if they wake you up around midnight, okay, or you need a rechargeable battery. Okay, what does that imply? You don't understand the subject matter you are dealing with. So, but the question is, applicants, do you understand what you're going to deal with? Okay, for you to be able to understand what you're dealing with, you should do what we call case analysis. Okay, so the presumption is you understand your client's case. If you are able to understand your client's case, all the grounds court bases on to grant bail, you can beat them. Even if they submit how, you can't fail to get bail. Okay? But some people are scared, they saw the affidavit in reply, and they said, now, my application has said that the client has a fixed place of abode. Now these guys are saying he doesn't have a fixed place of. So if you don't respond by making your rejoinder, the presumption is you have agreed. So how are you going to twist your facts to show that however much these guys have responded, but my client has a fixed place of? It goes back to case analysis. Okay. Unlike other questions, when you are cancelled for the week, this week, they don't give you evidence. You break your own evidence, but within the law, not outside the law. Okay. So you ask yourself, if we are going to deal with bail, do you understand the laws relating to bail? That's the first thing. Okay. because they are the very laws you're going to use when you're making submissions. Okay? So, applicants, what is the first principle that they consider to grant bail? The very first principle and the law where it comes from. Because these are the provisions you have to cite in your submissions. Okay? Council. What laws? Okay? So we have these general principles that every person is presumed innocent until he or she is proved guilty. So due to the fact that you are not guilty, you have a right under Article 23 to gain your liberty back. Okay? So now, your duty as counsel for the weak on the side of the applicant to protect the government so that this person doesn't gain liberty. Okay? So now, the presumption is we understand our case. So the essence of making case analysis is to get one, the opening statement. So we are starting with our opening statement. Yes. Both parties should have opening statements. Okay. So we are starting with the applicant. Okay. The way you understand your facts, the way you read the statement of the suspect, okay? How do you feel after reading his story? Okay? So that catchword that is going to really make your life, how are you intending to impress the judicial officer? Okay? How are you intending to impress the judicial officer? The opening statement. We said that an opening statement has two components. It has a theme and a theory. So we want to first start with a theme, okay? You as the applicant. So what do you think is the appropriate theme, okay? That word that is going to be the catchword, that is going to catch the attention of the judicial officer, that in case you start submitting, okay, the judicial officer will be able to tell that, yes, okay, this person is saying nothing but the truth. Okay? Are we together? So now, what would be our theme? According to you understand your case. Okay? Applicants. What would be the theme? That catchword. Senior counsel state brief. Assume tomorrow you've appeared before His Worship Kais. You've stood up, you've started, you've said, and don't forget. This, who's senior counsel tomorrow? The applicant, the respondent. Hey, applicant, don't introduce the respondent, senior counsel. You want to introduce the DPP. I saw someone who has submissions when you are introducing the DPP. Hey, leave the DPP alone. The senior counsel from introducing. Are you junior? Okay? Yes. So, we assume that the DPP has said that, my Lord, I am counsel so and so appearing for the state, and okay, and the accused is represented by Counsel Anita Karungi from Karungi and Company. Advocates, we are ready to proceed. After saying we are ready to proceed, now the rest of the applicants will have lawyers to speak in court. That's when you will start to say, my Lord, the The matter is coming up for an application for bail. It is by notice of motion supported by an affidavit deposed by the applicant, which shall be read and relied upon at the hearing. Okay. Then I've seen it is a new trend where you say, "My Lord, I pray, I proceed with my opening statement." But that was never the trend at the Bapos. Just say, "My Lord, we are ready to proceed." Then when they say proceed, they have given you leave to proceed. Now the presumption is Council Caron, they have told you proceed. So you want to open the applicant's case with an opening statement. Council Shahid. Okay, you get it? Because this is time you have to practice. Okay, this is your time because you're not going to understand it tomorrow morning. Okay. Okay, give us the theme first. Only the theme. Why? Mm-hmm. Hmm? Mm-hmm. Let's understand the speed. Okay. When you look at the statement of the suspect, he says that on the 8th day of February 2022. Okay. When is the matter coming up? When is tomorrow? 15th. So you start 15th of February. But if you look at this statement, when you go back to the complainant's statement, the complainant says that this guy, he reported on the 10th of February 2022. That's when he took action. So what does that mean? You count 10th of February 2022 up to the 10th of February 2023. Sent it here. Now plus how many days? Okay. Now you see. So if I can take her thing, justice delayed, justice denied. The state has laid to put this person at trial. And that means that if the delayed detention of this person is denying him justice, and among the things of justice, we have a right to a fair hearing. You have a right to freedom and movement. Okay? And how do you access that? Let court first grant you bail, then we shall see the rest. So I would go with her theme. Okay? Can say also the applicant. Okay? Do you have any other applicants here? Yes? Hey, Maria, give us your theme, your proposed theme. Okay? Look at the facts of your client and think. That's why I asked in the first place, do you understand your client's case? Okay? If you understand the case, it is a ground, okay, for you to be able to formulate these words. Give it a try. Give it a try. As a one rescue her. Yeah.
No, friend of.
However, a friend of God. But this we are all learning. Cancel. Look at the maxims of equity we have. Okay? You wait and see. Okay? Look at the biblical teachings and see. Okay? These guys want to incriminate your client for no good reason. Cancel Aish. You want to give it a try. Yes? Yes? Can someone to give them, can rescue them. Rescue them. But us. So when you look at the facts of your plant, that would be the first theme. Okay? Then come look at the Bible. Okay? Look at the Bible. What does the Bible say? Okay? What does the Bible say about freedom? Okay? Remember, the Bible says that God created. Yes? Okay?
Saying that the Bible, quoting the Bible, the case they cited, which was against it, that it creates bias to the judge and to the
What's the alliance?
bias. If you find the judge is a Muslim and you quote the Bible, or you find the, that case.
But we already studied the law, and we studied between lines. If you know that we have judges, they could be so you go by that, because the only thing you think is to impress the judicial officer. So first study the character of the judicial officer. Okay? If you're going to appear before her Lady Honorable Justice, okay, just know what words do such ladies want. Those are the words that don't make that mistake of going with things that create hatred. Okay, okay. So now look at first, when you look at the Quran or the Bible as well, because both have this. Okay, because God created both animals and men to enjoy freely without any restriction. Okay, at the start, that explains why the world has no boundary. You have to enjoy. This is a right that is godly given. Okay, but remember, so you should find means of expressing it. But applicants, I would go with hers. Okay, I would go with hers. She understood the homework. Probably she understood the facts very well. Okay, why? Because when you look at the time, okay, and those are some of the grounds upon which Kawempe, those guys of Kawempe have been pushing so much that continue detention. Okay.
I also wanted to propose this, if it can work, that is a doctrine that my Lord, there is a doctrine of natural justice, which is OD at alterem partem, literally translated to mean that no accused, literally translated to mean that no accused shall be condemned unless given full chance to prepare and submit his or her case.
That's such a fair try.
Yes. Okay. So from there,
Rules of natural justice. They apply. Okay. So when you look at the phrase I've just made about the world being borderless, you can say, my Lord, It is against the rules of, it is on the basis of the rules of natural justice that God created this earth without boundaries. Reason for all the creatures of God to enjoy the right of movement. It is on that ground, my Lord, the theory. Because you should be able to tell that this is a thing, this is a theory. Okay? So applicants, have we come to consensus on that? We want now to go to the theory. Okay? Because a theme is that one catchword that creates an impression while you are here. Then a theory explains the case of your client. Okay? So now let's get to the theory. Maria. The theme came from Council Karum. Now give us your theory. Okay? A theory is just words that you compose that will explain the nature of the case and the why you are in court. That's what this. You want to rescue us, friends of God, and rescue. Okay. Yes, Council Karunji, rescue us with the theme, the theory, and we'll see how did you come up with the theory yet, or
I think the theory is built on grounds that being seriously ill in the cell, in the prison, and he has been detained for a very long period of time. Yes, he detrimental to his health.
Okay, so Council is saying that in his submission that he thinks that the theory should be formulated from the grounds of appeal or of bail. So to me, I would, after saying that, let's assume we've taken her theme. Okay, you said that, my Lord, justice lays justice denied. Okay, now Council will, the judge will know that probably this person has overstayed on demand. You've not even started saying anything, but the judge will know that, why? Okay, then you say, my Lord, it is a settled principle of justice that every person charged of a criminal offense is presumed innocent until he or she pleads guilty or proved otherwise. Okay. Furthermore, my Lord, it is trade law that one of the fundamental human rights is the right to a fair hearing. And its components are a speedy and a fair trial. In the instant case, my Lord, the applicant is accused. It is alleged, okay, at that point it's fair use alleged. It is alleged that he committed aggravated defilement contrary to this section. Okay, except the section. It's murder. Oh, okay. Committed the offense of murder contrary to section 188 and 189 of the Penal Code Act. The Penal Code Act. The accused has spent on remand a sum of 1 year and 5 days. Because I think by tomorrow there will be 5 or 4 days, non-stop. okay, which is in total argument of violation of the fundamental human rights of the right of fair hearing. This explains why we have this application that the applicant is granted bail since he is suffering from grave illness which has not been cured by or maintained by the prisons officers. You've explained the rationale why you are here and the problems facing your client, because continued detention is a violation of human rights, and Council Anita put it right. Delay in putting this person, okay, to trial has caused an injustice. Simple as that. Okay, so we first stop there. Over to Mariva applicants. So now let's now go to the side of the respondents. We also look at the proposed deed and the theory. So now, respondents, yeah, we have only 2 applicants in this house, so applicants are being suffocated. Yeah? I also be the applicants. Okay. I also be the applicant. Okay. Now I'm always on the minority side. First versus abortus. Okay. So now we are the respondents. Respondents, do you understand your case? Yes. What is the strongest point in the respondents' team? In regards to bail. Okay. In regards to bail. What's the strongest point? Yes? What is the strongest point in regards to bail? Yes, sir.
So I look at the applicant's full age.
Yes.
If not falling in the bracket of exceptional circumstances.
Yes.
So this that I see no reason for ground
But you know that section 15, subsection 12, it says any of the following. So you can either be when you have obtained a certificate of no objection, if not that, advanced age, if not that, grave illness. So they can rely on any of those grounds. That one doesn't pass this. Securities. Depending on how your firm is prepared. The sureties your firm presented. The question you have to answer, are they substantial or not? How would you say? Do you have the yardstick that determines substantiality? Yes? Which sureties did they present? Yes. So to you, they're not substantial. Okay. You know why when we go to court, we always ask for the mother or the father first to be the first surety, or the wife, because they're the people who are so close. Tell him one agenda, mama. What's the age of the mother? Look at that.
She was born 5th June 1984.
1984. So if you count, that person is around 31. 40, 41. Look at the age difference between 22 and 41. So that one also doesn't pass the test. You have a ground.
Yeah, what if I'm not looking at that? They're looking at the financial status. They did not provide that because being a mother doesn't mean that she can be assured if she cannot provide that.
How sure? That's why they say non-cash. That's why sureties are given non-cash. The issue of substantiality, just put it aside. Leave it at the discretion of court. Read your facts. Okay? Read your facts line by line. Look at the character of the applicant.
Because the accused, they are stating that the accused is the citizen.
So your strongest ground is on his character. Look at the facts. Why was he in prison?
He was in prison
for which offense?
Because first of all,
even before serving the punishment, this person committed another. It's like stealing from church. You've gone to repent and steal from church. Okay? So after repenting, you know that Karum where they go. After repenting, you come out, you see a bag of offer, you say, yeah. You look at that. Now, if this person is out, okay, how many offenses is he going to commit? If you can commit, go to your police. Okay, imagine you are detained for committing an no one on your foot is out. You see? So that is your strongest point. That's why I told you. First, understand your case before you do anything. Okay?
Pending investigation.
Pending.
My client was in the wrong place at the wrong time.
But why is this everyone is there?
Yes.
We shall tell. Okay? We shall tell. So now, let's get back. So from that, your duty as the respondent to ensure that the law is at its play, okay? So that we follow the strict letters of. Then on top of that, what offense is he being charged with? Murder. Okay, it's a capital offense. You go to, those are some of the grounds upon which court will incline to grant bail. When you read section 15, subsection 1. Okay? Under the offenses that are described upon which court should incline. The nature of the offense and its punishment, the gravity of the punishment. The nature of the offense and the gravity of the punishment. Okay? So the nature of the offense is a capital offense. When you look at section 189, the punishment of murder is death. Okay? Just of namufinika accident over the just now imagine everything is clear. You killed. ng'okimanyi bwe banteerayo sifuluma. Ne bakutaamu katono nnyo bwe kati. Katono nnyo bwe kati. So you see, so those are your strongest points. So now, when you are formulating your theme and the theory, it should drive court to that. Now, respondents, let's get the theme. Remember your duty, you're representing our good government. Yes. Council must give us your theme. That would be a better opening statement for a big trial. When you are seeking, you know what we call aggregating factors? Never. So,
What if I say, the punishment of sin is death. And I said that in this circumstance, the wages of sin is death. And therefore,
we shall get there.
That nailed it. Look at Matthew 5:21. It says that you shall not murder, and whoever murders will be like judge.
It's in the same line. No, so you are deriving from the same authorities. Okay? So you guys want a kill just like that. It's still young.
There is a young life that
Public, private interest. My Lord is a threat to release charity from both first time. And his
Private interest. Well, that one can come in the theory now. The theory. Respondents. Two of them. Your catchword is in the Bible. Okay. How many days did this gentleman spend in the fish, Jonah? How many days?
3 days.
Why was in that fish? Okay. What's the rationale behind criminal law? Punishment. What are the ingredients of a penal provision? It has a sanction, and so. Oh, no, we are not writing yet, but I'm showing you that where the law is set, okay, if God punishes us, okay, for disobeying his laws, what about you? Okay? Those are the God-given laws. You see, we say why? This is disobedience of the law. Okay? This is disobedience of the law. If God, who gives us the brains to enact these laws, punished Adam and Eve, okay, punished Jonah and imprisoned him in the fish for 3 good days without food, okay, without seeing any light. But imagine, this guy is in Ruzira, okay, is in Ruzira, he eats food, he sees the light, he gets medication. Was Jonah getting anything from the fish? Yeah? Imagine. and you say that this guy gets out. Jonah waited. God told him, be patient. Okay? Be patient. He used to just hear like a voice, not so. Be patient. Wasn't he patient? So, why is Eli impatient? So let's get our theme now. Okay? It should be from the Bible. Yes, Master. Yes. Yeah, find means of praising it. Because all those guys, they were disobeying the commandment. So, God. And the punishment of what you can't disobey and you not punish. So one of the punishments of disobeying the law is detention. Okay? So you want this guy, after disobeying the law, he has been detained. You want him out. Where is justice there? Okay. About. Okay, let me answer.
In the Bible, when Cain killed Abel, he was punished.
Which is Exodus what? Okay, let's say this. Okay, he said, my Lord, Exodus chapter 20 says that, oh, you who believe, I have sent to you the 10 commandments for guidance. The 10 commandments are the laws, because when you read the 10 commandments, they cut the entire, everything we do. Okay? All the sexual-related offenses, murder, everything in the 10 commandments. Okay? You see why? You are saying that all you who believe, okay, I've sent you the 10 commandments for guidance. Okay? If the 10 commandments guided everyone, inclusive of Moses, okay, what about you? Okay? You get it. Then after that, you can bring, okay, the slogan which says that, one shall not kill. Okay? Then after that, now you cross, okay, to the theory. Yes? That is perfect. Okay? Then you say, one shall not kill, for the wage is, the wages of sin is death. You leave it there. Okay? You've already stated literally the penal provision which talks about that offense. Okay? Now we go on. Okay, now we're drawing now in our view.
The other system might say it doesn't apply.
No, you see after, because what we want, the laws relating to murder from the Bible. That's why we had to first quote Exodus, because it is the book in the Bible that reveals the 10 commandments. Then after the 10 commandments, and an obligation to get any of the teachings in the Bible that talks about one should not kill. and its punishment. Either you use that, okay? He who kills another deserves death, whatever, okay? The way you phrase it is okay. The one you phrased can also be added on. The one she phrased, so both work. What we want, the law and the punishment from the Bible. So I've given you the law. You have the provisions that talk about the punishment of causing death. You stop there. Okay. So now we'll go to the theory. Yes. We've said when you are making your theme, we want the law and the punishment.
Yes.
I've given you the law. The law are the 10 commandments. Because inclusive in the 10 commandments, you're not supposed to kill. Then, which biblical phrase talks about the punishment of causing death? That's why she said you can add on what she said. If you're not taking that, you can add the one you gave us first.
Can't you give the three of them?
You can, because you call up creativity, okay? So that you don't leave room for the applicants. You have to close all the gates so that no one enters heaven if this person killed. Okay? So we go on, but in practice, we don't do opening statement. Just go you die. Yes.
They discussed the constitution we want them to remain in prison and not be run.
Yes.
So what I would be for them is that the justice will demand that like justice, like the justice you say should really see that like justice should not just be hard work, but it should be seen to be done. Because they read this one, for instance, or when you read the pattern, for instance, the public will argue and say that
Okay.
when they start arrested within
Okay. Respondents read the case of Katoka versus Sudan. What she's arguing. Okay. Okay. What she's stating, that was submission of counsel in Katoka Jury's application for bail, because they said it is in the interest of the accused to be detained. Reason, there is what we call public outcry. His immediate release will depict a wrong image in the public. Okay, that his continued detention is in the best interest of the public, because justice should prevail on the side of the public. That was the that it was in his best interest, because it is okay. Because he had good lawyers who know how to argue the law. Okay, as counsel for the applicant. Okay, so now let's get the theory. Okay, so we can say, my lord, equity shall not suffer a wrong without a remedy. Equity shall not suffer a wrong without a remedy. A wrong without a remedy. My lord, if our Heavenly Father punished Adam and Eve for disobedience of the law, and also punished Jonah by detaining him, okay, for 3 days and 3 nights, staying without light and without food and water. Okay, and punished Jonah by detaining him for 3 days and 3 nights without water, food, and light. Indeed, whoever disobeys the law needs to be punished for justice to prevail. For justice to prevail. My Lord, the matter before this honorable court concerns a young, okay? The matter before this honorable court concerns a young, courageous man who would be of great importance to the public. The matter before this honorable court concerns a young, courageous man who would be of great importance to the public. However, he turned into Madara will sound a bit funny. He turned into, get that word, okay? Like 3 of them. One, he turned into a disgrace. Now, disgrace, why? Apa, mutembe, you still have energy. You can work, okay? A disgrace, what else? A nuisance, because focus just move around, okay? And you say endless danger, okay? Who deserves to be put out of the society for proper management, and who deserves to be put out of the society. Reason, one rotten tomato can destroy the entire basket. So that you see, him overstaying in the family, a lot of people within his age bracket may end up like, so let us pick him out of the public. That is the rotten tomato. Hopefully, actually, we're the same page now. So, okay, so now we are there. Okay, so are we at the same page? Now, after that, you've opened your case, both sides. Okay, now it will be the applicant to go on to start, okay, adducing their evidence to state a ground upon which they are basing their application. Okay, they should adduce their evidence. And which type of evidence are we using? Affidavit evidence. So what does that mean? Is your affidavit sufficient? Eyogera. Okay? Is your affidavit sufficient? Okay? Yes. Now what sometimes that's how it's done, but in criminal you go once, okay, the applicants, you go once, then the respondents they also come. Yes. Okay. Yes. So now the presumption is we are there. So now it is time for escalate submissions. But your submissions should vary depend on your affidavits. So at this point, we expect the applicant to be having 2 pairs. That is an affidavit in support and an affidavit in rejoinder. Once you don't file an affidavit in rejoinder, you cease to have a right to make a rejoinder when you are making submissions. Okay? So, beginning with that. Now the respondent expects you have 1 affidavit. So make sure your affidavit is self-contained. It has everything. Whatever is missing, you're not going to rely on it. You'll be submitting on the back. So you have only one chance. So that means your affidavit should have a minimum of 18 paragraphs. A minimum. Because if you don't meet this guy's, that case is good. That's the making it true. This over detailing this guy, you're joking. Okay? You're joking. Okay? You can't remand someone for a year before being paraded in the High Court. Okay? Yes. So, we want to make submissions. Obviously, I'm starting with the applicant. Okay? Yes?
I've already served.
No, but we have to make things more clear. So now, what you should note, when you are drafting your affidavit again of 4 marks, they're just testing your ability. Make affidavit the marks. So whatever is missing. So now, the applicants, how many grounds? We have what we call the core grounds and then other grounds. Okay? So now, applicants, how many grounds do you think you have? The core ones. And the core ones. Fixed place. Okay. What are the grounds court bases on to grant bail in the High Court? To get up section 15. Okay. I'm going to put it in favor of the applicant, then I turn it in favor of the respondents. That's how the law works. We use the same authorities. Okay. That's why people say, the soya fundira lawyer. By name the okay. You ladies, you've been with these lawyers. I said, oh, they are loyal. Seems like she is a victim. Okay, are we there? Okay, so section 15 says release on bail. It says that okay, so we are basically interested in 15. It says that notwithstanding subsection 4, the court may refuse to grant bail to a person accused of an offense in subsection 2. Okay? Now, applicants, when you read this section, it talks about discretionary powers. So the discretionary powers are only exercisable to what? To offenses under. So what does that mean? In the first place, okay, the offense that you are charged of is a variable offense because the law allows the High Court to grant you bail. Okay, because it says, okay, notwithstanding section 15, the court may refuse to grant bail, okay, to a person accused. Mere using the word may, that means court may grant or may not. So what does that mean? It is a bailable offense. Already you're on ground. The offense is bailable. So you will proceed on an offense which is not bailable. Now, after understanding that the offense your client is being accused of is bailable, then ask yourself, what grounds does the court base on? Those major grounds. Okay? It says, if he or she does not prove to the satisfaction of court that A, the exceptional circumstances exists to justify his or her release. So now, ask yourself, what amounts to exceptional circumstances? Okay, so what does that mean? If you are the applicant, let me tell you, the sweetest thing is for you to submit on those grounds that are under the law. So what I urge you, you are two or three. Okay, if you are two, choose those grounds. Leave for your colleague those that do not have substance. Yeah? You get it? So, what I would implore you, go for the first ground, exceptional circumstances. Okay? Because why? It is when you are flowing, it gives life, and you know when they're giving marks, they first look at the way you added up your wording, yeah? The choice of words, the way you are flowing from this section, you cross this, you go to this, you give them a case, and yeah, one akiman. Okay, so now when you read the law, the first ground is no exceptional circumstances. Okay, so when you are making your submissions, we expect you one. You've already given us the brief, but remember you need to categorize of submissions, written and oral. So your written submissions will have what we call the brief. Okay, what will be your brief facts? You said that the applicant on such a date, this happened, he was discharged, okay, of this offense, has been intention for this and this, okay, he took a plea of not guilty, hence this application, okay. Then after giving the brief, you go to what we call the law. What law are you going to base on? Okay, so you first cite for us the laws. So we shall start with Article 23. Okay, clause 6. Okay, Article 23, clause 6A. Okay, then after that you go to Article 28, clause 3. Okay, which talks about the presumption of innocence. Okay, so at this point, remember, your client is presumed innocent. You get it? Then after that, okay, you come to the TIA because we are in the High Court. When you come to the TIA, you start with section 14, which says that the High Court may at any stage of the proceedings release the accused person on bail. Okay, why? You want that word at any stage. So at what stage is the matter cancelled? At the stage of the trial. So that means we are still within time to make an application for bail. Okay. Then after that, go to section 15. Okay, which gives, then you say that, my lord, the grounds upon which this honorable court bases on to grant bail are clearly set out under section 15 to include. Now you start giving us all the grounds. We just outline to include one. Okay, existence of exceptional circumstances. Then 2, that the applicant will not abscond jurisdictions. Then 3, that the applicant has substantial sureties. Then 4, that the applicant has a fixed place of abode. How many are they? Okay. Exceptional circumstances, fixed place of abode, substantial sureties, and will not abscond jurisdictions once bail is granted. So therefore now, okay. Then after highlighting them to the judge, then you say, my lord, we shall proceed in that order. Okay. So remember, you are 2. Why? Make sure Guasoka or substantial sureties and exceptional circumstances. Why? Zinuma. Okay, you're going to shine. Okay, then you say, we shall proceed in that order. I will submit all ground 1 and 2, and my colleague will submit all the remaining 2. I pray to proceed. Okay? Yes?
Council, especially in the exceptional circumstances. It's like I'm finding some difficult for one to take up that, given the applicants, you can move forward under. So,
I'm going to see the topic that we are going to do it. Okay? So, Maya, I'm hoping with your affidavit support. Okay? You don't have? You can also help me with your affidavit support. I'm going to submit on the 2 grounds there. I'm going to make submissions on substantial changes and you can forward. If you have a PDF, you can forward. Okay? But she has to.
it's forward in the
No, those are readings. Yes, forward. Okay, so you will submit, and then after that, also make submissions for the respondents. You see how the game is good. Okay, we use the same authorities and use governments. Okay. 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 Slowing us. We are making submissions on ground 1. Okay. So we are taking which ground? The first ground we are taking is exceptional. Then the presumption is you have informed the judge that we shall proceed in that order. I will proceed with. Okay, then you start. You said then you said ground 1. Okay. Remember, your ground 1 is defined, not so. Then you say, my lord, section 15, subsection 3 of the Trial on Indictment Act is to the effect that exceptional circumstances mean any of the following: A, grave illness certified by a medical officer of the prison or other institution or place where the accused is detained as being incapable of adequate medical treatment while the accused is in custody. Okay, that's 1. Then you say 2, a certificate of no objection signed by the Director of Public Prosecutions. Then 3, the infancy or advanced age of the accused. So now, just note this. Tell DPP go agenda for certificate of no objection. Okay? When the DPP to withdraw from responding from the application, it only happened yesterday. Okay? In Masaka. Only. Okay? I don't know. Okay? Then, secondly, okay? Secondly, look at the suspect's plain statement. How old is the suspect? So that means the 2 grounds of exceptional circumstances accused the why. Asigaza wetya the applicant muwayize musibeke ekirwadde ekitamala gakola ki gawona. Kati between lines. Okay, why? That means we are remaining with only 1 exceptional circumstance, which is grave. Katuro ye grave illness. Now gambe ya wallahi mulwadde. Kino bakisobola. Cancer Mary, which grave illness do you think is better? Abdominal pain. Huh? Cancer. Which cancer? Which cancer? Cancer. What grave illness? Yes. Was that one? So now, but whatever disease you are talking about, you come here. The section says that it should be proved by a certificate of a medical officer from prison. Okay. Now, then after, when you are submitting, you'll give us all the 3 exceptional circumstances. Then you say, my lord, in the instant case, the applicant relies on the exceptional circumstance of grave illness. Now, we want evidence of grave illness. Where are you getting it? Now come to your affidavit. Okay? Then you say, in the instant case, my lord, it is the testimony of the applicant in his affidavit in support, which paragraph? Then you come, okay? You look at the paragraph where the applicant says that he's suffering from a the affidavit in support of counsel Anita's. Okay, so when you look at so for counsel Anita, when you are proving that, you'll come to your affidavit in support. You say that it is the testimony of the applicant in his affidavit in support, paragraph 8, where he states that he is suffering from grave illness, to wit, prostate cancer. Okay, to which prostate cancer, which the prison's medical facilities have failed to provide adequate medical attention. My lord, a copy of a certified recommendation from the medical officer from Rosilla Upper Prison is attached here. Why? The provision says you should have a certified, so then that is from the law. Then haven't you proved? Okay, but remember, do not take away data to close room for these guys. Mere medical attention is not sufficient. Okay, then you say, furthermore, my lord, it is still the testimony of the applicant in paragraph 9, where he states that the applicant needs immediate medical attention and operation for the betterment of his life. Attached is a copy of the medical recommendation from Murago Referral Hospital Cancer Institute. Operation. The urgency of this person getting over all we need to show that urgency that he really needs to get out. Our cancer institute. It is impossible. So the only option, you've proved that he's sick, yes, and you went that extra mile to prove that this person is suffering from grave illness and he needs immediate, you underline the word. So the more they delay, remember our theme, justice delayed is justice. So we want to get out that delay. That's why we use the word immediate. That's one ground, one man down. Simple as that. Okay? Simple as that. Then you say, my Lord, I'll proceed with ground 2. Okay? So you say ground 2 is that the applicant has substantial sureties. Okay? That the applicant has substantial sureties. Okay? Okay? At that very point, that the applicant has substantial sureties. So when you start submitting on substantial sureties, that's when you're going to tender in their credentials. Yes. Okay. When you get to the issue of substantial, yes. Okay. No, buying a copy, but to do it, okay, to give it life, yeah, because it is on record for just purposes of identification. Okay, so you need to make a prayer that they are adopted. You get it? They are just there for identification. Yes, and you find them substantive. Once you don't record it, they are not substantive. So we say, okay, we say, my Lord, in the case of Geno, which Geno? In the case of Geno Tumukunde versus Uganda, court defines substantial sureties to mean persons with control, control over the applicants. Okay. Then proceed and say that, my Lord, in the instant case, the applicant has adduced how many? Okay, you said has adduced 3 substantive sureties, to which you mentioned the first one. Okay. Remember, it again in our trial advocacy, we have what we call after case analysis. We have another known as trial strategy. So when you are arranging your sureties, so say you are man. Okay, you say to wit 1, Madam so and so. Okay, Madam Narukenge Jennifer, to wit the mother of the applicant, aged. You indicate the age, then after the age, you say a resident of. Attached here too is a copy of their national identity cards and introductory letters from the local council. Okay, my lords, their credentials are attached to the affidavit in support. I pray that court admits them for purposes of finding them substantial surety. Okay, I pray that court admits them for purposes of finding her a substantial surety. Okay, then after getting done with the sureties, then you say, my Lord, I pray that has proved beyond reasonable doubt the first 2 grounds for this honorable court to grant him bail, much of blood. Okay, we say that, my Lord, we pray that this honorable court finds that the applicant has proved the first 2 grounds for granting bail this honorable court beyond reasonable doubt. The applicant has proved the first 2 grounds for granting bail in this honorable court. In this honorable court. In this honorable court beyond reasonable doubt. much obliged. I pray that my colleague proceeds from there. Then your second colleague will come. I was no grounds in the car. And same as that. Okay. Yes. It is too late. It's the odd. They gave this facts when they are leaving one exceptional circumstance. But creativity is a mark. Yeah, what every shoot you mention will stand up, and the court will direct them where they stand. Okay. Any question how we make submissions? I want to make submissions for the respondent now. Okay, but we are rebutting seriously. Okay, we are going to use the very two grounds. Okay, so what does that imply? If you are counsel for the respondent, again, still choose those two grounds. You respond on them. Okay, as counsel. Now, mark this. When these guys are making their submissions, you note them down. You know why? You have to make a rejoinder. But the law is a rejoinder is restricted basically. Okay? Basically to what has been submitted in. Okay? Make sure you note that. Okay? So let's go to the respondents. We are making submissions. Now, respondents, mark this. Okay? The grounds that you have, you can't dispute the exceptional circumstance. You can't. Because they have a medical report with a stamp from prisons. Tebabusobola gamazima. Mugenda kwekwata kuki kubisubi. But how? The respondents. Once if your team has adduced that report from prison, okay, you get it. But I'm sure there is a team which has a mere write-up, not that extra mile of creating a headed paper of prisons, what and what, a mere write-up. You can dispute that it is not authentic. You get it? Authenticity of it. Look at the documents that have served you. Open their medical report from Ruzira. Does it really look like a medical report or not? If it doesn't look like a medical report, it is not authentic. So it is relevant, but inadmissible. But that requires when you have your affidavit, you would have looked at it, we see its authenticity. Okay, and I show you how you can beat it. But if they have, but ask yourself, how do you rebut? Okay, how? You start the very way this guy starts. Okay, you can start, you say, my lord, the provisions of article, the provisions of article 28 and 26 of the 1995 Constitution are so emphatic on who courts to consider when granting bail. Are so emphatic on who courts to consider when granting bail. My lord, the grounds upon which this honorable court bases on to grant bail are clearly stated out in section 15 of the are clearly stated out in section 15 of the TIA. Okay. 15 of the TIA. Okay. Section 15 of the TIA to include the following. You also state them. Okay. You also state them to include the following. One, existence of exceptional circumstances. Then 2, substantial sureties. Then 3, fixed place of abode. Then 4, yes. Okay. Substantial sureties, then fixed place of abode. Then for your case, you as the respondent, you should be so keen. This section gives you a lot of power. Okay? Because it says that, okay, notwithstanding subsection 14, the court may refuse, underline the word, refuse to grant bail to a person accused of an offense specified in subsection 2. Which ground is that? Okay, you indicate here nature of the
case.
Nature of the case and the gravity of the punishment. Okay, nature of the offense and the gravity of the case and the gravity of the punishment. Nekati gwa applicant eyo togitunulako ekikuba tokyogerako obojja kwetta. Okay, gravity of the punishment. And then lastly, the discretionary powers of this honorable court. My lord, we shall proceed in that order in responding to the submissions of the applicants. I beg to proceed with ground 1. Okay? My lord, we shall proceed in that order in responding to the submissions of the applicants. Okay? So now you have to choose now ezikolera zomanyi teziriko bizibu ezikuyisaawo. So what I would advise you guys, okay, the best, I didn't look at your affidavits. Okay, I didn't look at your affidavits. It would be better, okay, for you to depend an affidavit ngerimu paragraph egamba that it is in the best interest of the applicant to be detained. Komanye ekintu ky'okutta nga buli wetaga oyatta gundi. You get it? Okay? Because that's the ground you're going to cite to give court the discretionary powers. It is Katoka, you had it all. Yaleta bashutis natamanyi maanyi ge balina. Nga ne bagamba meka as why, because the guy had money. Okay? But only that ground, because, and you get time and talk with Counsel Robert Mackey. When you read that case, is mentioned somewhere. So that means he was part of that case. Even the case of Bad Black, Bamuako bail. It was that man in those 2 cases. Oh, you will bamuyita. Ngale kusaidia state. Tosobola kugira bail now. is hard. Okay. You guys proceed. Yes, which grounds should we go with? Let's go for substantial sureties. Okay. Round one, substantial sureties. Now, council, you rejoin that. You end up calling substantial sureties. Yoka. Okay. How you're going to rejoin? Because these guys are going to say that you don't have substantial sureties. Okay. Then we shall say that you use the same case. General Tumukunde versus Uganda. Court held that substantial sureties are a case-to-case basis. Not all times we consider the same factors. Are a case-to-case basis. Okay. And in analyzing the case-to-case basis, emphasis should be made on the following factors. One is a case-to-case basis, and emphasis should be made on the following factors. One, age of the surety, reputation in the society, and control over the accused. Control over the accused. Now, I want you guys to be honest. Okay? If this guy committed the first offense of theft, the aina mama. You get it? You get it? Okay? So that means these guys, regardless of their age, okay, they did what we call child neglect. They neglected the child. That means they no longer have control over this person. Whatever it is, after 22 years in Omwana Mtembe. Ngabamusibako ne kugo. Abata kuiseko. Okay, we go on. So then we go and say that. Okay, we go on and say that, my Lord, it is the testimony of the applicant in his affidavit in support paragraph 1 that he is a male adult Ugandan aged 22 years. But his facts show 21. Okay. Okay. That he is a male adult Ugandan aged 21 years. Okay. My Lord, it is furthermore submission of the applicant that he has paraded the following sureties: his mother, a close friend, and his mother. Okay. Paraded the following sureties: his mother, a close friend, and a workmate. My Lord, it is so absurd that the applicant committed the first offense to which he was still detained in police cells in the presence of the said substantial sureties. It is, my Lord, it is absurd that the applicant committed the first offense of theft, okay, even in existence or availability of the said substantial sureties. It is a clear indication, my lords, that okay, offense of theft in the presence and existence of the said substantial sureties. The said substantial sureties it is a clear indication, my lord, that the substantial sureties cannot in any way execute their obligations of having control and power over the suspect once he or she is granted bail. Cannot exercise or cannot execute their duties over the suspect once granted. Okay. So we therefore pray that this honorable court finds that. We therefore pray that this honorable court finds that. This honorable court finds that the applicant has not adduced any substantial surety. Has not adduced any substantial surety. Hey, woman was beaten na mama uliyomdaba. Mama yaja kwa polisi mofacts. Hey, segeza singa teyatta. These guys have they wouldn't have appeared. Tebalina makulu. Hey, that is the law. We use the same provisions of the law in some cases, and we choose lawyers are storytellers. Counsel for the applicant, category rejoin. Okay? Counsel for rejoin. Okay? Mwetemu kwa rejoin. Kwa church vachu wede, ori I know kwa rejoin. So the counsel rejoin. Okay? Then you say, my lord, I appreciate the emphatic submissions of counsel for the respondent. Okay. I appreciate the emphatic submissions of counsel for the respondent. However, I'd wish to draw this honorable court to the provisions of section 33 of the Judicature Act because it applies in both civil and criminal. Okay. I will ask for counsel for the respondent. However, I would like to draw the attention of this honorable court, the provisions of section 33 of the Judicature Act, which is to the effect that the High Court may grant any such orders for purposes of justice. Okay? For purposes of justice. Okay? Furthermore, my lord, reference should be made to the provisions of section 14 of the Trial and Indictment Act, which clearly states that, furthermore, reference should be made to the provisions of section 14 of the TIA, which clearly states that the High Court may release the accused person on bail. That is to say, yes, the High Court may, at any stage in the proceedings, release the accused person on bail. That is to say, on taking from him or her an amount a recognize consisting of a bond with or without sureties. With or without sureties. Sureties. you can pass the test. So I'm chobogera ko kibachimanyi. Olaba feka twakat gena weed tubalete no bale. Okay? Okay? So then you say, therefore, my Lord, we pray that this honorable court invokes its discretionary powers to find that the applicant has adduced substantial sureties who know how to execute duties of a surety. We do so pray. Thomas said, has adduced substantial sureties who know how to execute duties of a surety. Tomo to respond in the qualification formulas section example with or without. You've just made work easy. Okay, for the judicial office. Simple as that.
It was still paying You're limited to only
what they have.
But what if they talk about it in court?
Now, actually, what you would say, or what you would respond to that ground, because I know they made in their submissions in class. Because I know they want to talk about it. They want to depict his character. Okay? That matter was still pending investigations. You'll use the presumption of innocence. Simple as that. Okay? So, is making submissions hard? So now, what was hard? Okay? So, all of you guys are appearing tomorrow or some on Friday. Maso, are you appearing? Friday. So, what are you supposed to do? Whoever is appearing on Friday, I'm very sure your judge has a matter tomorrow. Kasad, it's funny. Almost killed me in horrors. So make sure tomorrow attend where he is. Okay? That is the technique. Go to the timetable. You see which farms are prevailing over Kasanda. You go attend. Why? Because these judges need different things. Okay? That's why for us we go to court when even you don't have a matter. Go to okay, I have a pending matter. Okay, when you know you'll be grilled, go and attend so that Tokola so these guys, the things they want today. I told these guys that in the week of land, I appeared before His Worship Kais. I told what the guy doesn't want. Those who appeared before him, the guy even threw the papers. Why? The affidavits were lacking. Automatically, I told because I've ever attended before. So they are things they want, they'll never change. Okay, so please attend, and tonight go and prepare. Go in the mirror, redo these things so that bikuberako. Okay, so allow me bring this session to an end. Those colleagues want to clean, however, cancel for the week. This is your first written exam. Okay, I know you guys are going to make it. Go and shine. Go and represent us. Go and represent your families. Represent your husband. Represent your wife. And above all, represent yourself. Okay? Go with that exciting beauty. Okay? Put on that classy suit. Hey, over jaja kunrako naga I want. Akuweza smartness ekisigado bikole ki agende okujjanga ne mato olina agani kalusiku watulabe. Okay, so you guys, I declare you winners. in the mighty name of our Lord. And I believe you're going to make it. The sky is no longer a limit for us. Why? Okay? Our voices are heard straight forward to the Lord. Okay? There is no sky can limit us. So let me wish you the best of luck. May the good Lord bless you, grant you wisdom, knowledge, and understanding. Let's meet tomorrow for accounting and taxation. Assalamu alaikum wa rahmatullahi wa barakatuh.